Honourable for St. James North.
Thank you, Mr. Speaker. I rise in support of the bill before Parliament here today, the Child Justice Bill. And I think it's essential, sir, as the immediate past Home Affairs Minister, to give a background on the issue and to contextualize what we are debating today. This bill, when it becomes law by proclamation, signature of the President, will repeal two extremely outdated pieces of legislation, sir. One, the Reformatory Industrial Schools Act, 1926, and then the Juvenile Offenders Act of 1932. Both of these acts essentially passed in this Parliament 100 years ago. Very few Barbadians were alive when these two pieces of legislation were passed. We were in a colonial state, sir, not that far past slavery. The conditions of our people, black people in this country, were essentially not much better than they were during slavery. It was just, of course, after the First World War, in which Barbados, as a colony of England, was involved and Barbadians fought. It was a situation, of course, before the 1937 riots and the subsequent Mon Commission, which spoke about the depraved and the humiliating conditions that black people lived in this country, sir. So within that context, those two pieces of legislation were passed to essentially keep children, black children, where they were, in the station where they were born. So they had flogging. You could be put in the detention center, whatever it was called then, sir, because you were on the road begging, because you were asking for alms, as they called them then, at that time, because you were in a social and housing environment where prostitutes, that's the word used, lived and went on, because your father was convicted of sexual offenses involving young girls. All of that could automatically land you in a detention center, sir. And the law there then, and it was unconstitutional, and we still have the law today up to when this act now becomes law. Certainly unconstitutional. And when I was Minister of Home Affairs, it troubled me tremendously that the minimum sentence for a child to go to government industrial school, DODS, was 3 years. A magistrate had no discretion to sentence a child to less than 3 years. Minimum 3, maximum 5. Had to be unconstitutional, must be unconstitutional. And I've spoken with you on previous occasions, Honourable Speaker. You know that we've spoken and discussed this because it doesn't happen for adults. For adults, a judicial officer has a discretion, whether the judicial officer is a magistrate or a judge, to sentence on conviction an adult to less than 3 years. But here we are sentencing children, 13 and 14 years old, to a minimum of 3 years in a detention center. Absolutely unconstitutional. And it is really, sir, an indictment, I must say, sir. And if you can't speak freely in this Parliament, you can't speak freely anywhere on previous governments, previous administrations, sir, that today, which should have happened long time ago, has finally only now come. There was a 3-day conference, sir, in April 2015 under the last administration where child justice reform was discussed. sir, I think funded by the United Nations, representatives from the Organization of Eastern Caribbean States were present, and in fact, a model OECS bill was constructed and crafted, sir, which some of the countries in the OECS have used to pass legislation already. So Antigua has similar legislation in 2015, St. Vincent in 2019, St. Lucia in 2021. But we lagged behind. And the model legislation was there. So when I became Minister of Home Affairs, a document was brought to me shortly afterwards. It was called a Juvenile Justice Bill. That's what it was known under the last administration. And I was told that this bill was lagging on the then Home Affairs, the former Home Affairs Minister's desk under the last government, the then member for St. Philip South, for about 2 or 3 years, and he did nothing about it, like he forgot that the bill was there post this 2015 April conference. And when you look at the files, as the Honourable Member for Christchurch East would have seen, in February, suddenly it seemed like if the Honourable, the then member for St. Philip South, like his leader, woke up from his slumber and said, but look, this bill needs to go to Parliament. And the Cabinet in February 2018 then gave approval for this bill to go to Cabinet. But of course, by February 2018, in fact, the last administration was already over time, was past its 5 years. And in March, I believe, within a couple of weeks after that, we walked out. Opposition members of Parliament said we're not coming back because this is ridiculous. 5 years is accepted as the time frame for a period between elections, and we are not condoning this. So the then Minister of Home Affairs had no opportunity to carry out the mandate at the 12th hour of his cabinet to bring that bill before Parliament. So we found a situation then when I, as Home Affairs Minister, was given the authority by Cabinet. In fact, Cabinet set up a Cabinet subcommittee on child justice and on child protection to look at these bills. And they had quite a few ministers. I led that subcommittee, quite a few ministers on the committee, and public officers as well from all the departments, probation, obviously government, industrial, school, etc., with a view to getting this in. In May 2019, I would have taken a paper to Cabinet, and Cabinet approved in principle this bill, the Child Justice Bill, but said that we had to now see how we're going to implement the bill, because it was bringing fundamental changes to the legislative platform of child justice. And also, of course, even after then, we would have got the assistance from the United Nations, UNICEF it was, who paid for a consultant to do a framework, written framework on how to implement this bill. We were held up because the child wasn't ready, as we heard last week as well. Because then the Child Protection Bill also, at least that legislative framework, also got a consultant to assist them. That consultant was a Barbadian, Mrs. Jackie Burke, Seeley Burke, who lives in Grenada, a child rights expert known throughout the OECS, and she would have helped then with the child protection legislative framework. So that is the background, and the reason why this suppose is only now coming to Parliament 9 years to the month, because it was May 2019 that the Cabinet approved this legislation. When I read it through this morning, again, sir, it wasn't that much different from what I left behind when I demitted office as Home Affairs Minister. But obviously we had to, it couldn't come without child protection. Clearly needed consultative process again, Joint Select Committee. We praise, as was previously done by the Honourable Member for St. Michael South, Mrs. Faye Marshall Harris, our ambassador on child rights at the UN and other industrial places. She assisted me as well a lot in it. She had done, even before I became minister, a comprehensive paper on child justice and showing the severe defects in our legislative framework and what we should be doing to get us where we are today. And I have to also praise the Joint Select Committee, as I did last week, on the process which it went through and allowing the public to feed in and have their say on this legislation, even if many changes, few changes only were made. And so indulge me please to speak a bit of the Joint Select Committee process. We also have at the present time the Policy and Governance Committee looking into, Joint Select Committee of both Houses of Parliament looking into the cybercrime bill, sir. And the Honourable Leader of the Opposition, I regret, sir, that he has not contributed. He could still come and contribute, sir, to this debate today. Perhaps it is that he said everything he had to say last week, has nothing more to say now. But he made some statements, that Honourable Member, on Sunday, sir. And I heard his voice. It wasn't that the news reported what he said. It was his voice on the cybercrime bill and the hearings that are going on now, because he's a member of the Joint Policy and Governance Committee. And last week, Monday, he was present and engaged the Honourable Member for St. Michael South Central, the Minister responsible for presenting the cybercrime bill in this Parliament. So he knows that what he said was not the truth on Sunday. When he spoke somewhere in Bridgetown, I believe, they said it's some Marcia Week's political meeting. Every week, the marching, the talking. And as I said last week, I protect their constitutional right to do that. But the Honourable Leader of the Opposition has a duty to this Parliament and to the people of Barbados not to perpetuate inveracities. If I was another place, I would say something else, but that would be unparliamentary in here. And I heard him say that the bill, cybercrime bill, is made only to deal with Barbadians that live here. And that we come in to lock up Bajans who live in Barbados. And that it is not, it does not speak to Bajans who live outside of Barbados. So I could not believe my ears that a silk, someone who is a senior silk in this country, who knows better. I'm not saying that he ought to know better, because I know he knows better. He and I went through law school, law faculty together 40 years ago. I know that he knows better. I know that he knows he's not telling the truth, because we engaged him last Monday. He asked the Honourable Member for St. Michael Central a whole series of questions. Some of it on social media now. And the comments on the social media are that he behaved badly, he's a disgrace, etc., etc. So I know he knows that when Section 3(1) of the cybercrime bill as presently drafted, this act applies to an act done on a mission made by a, subset 3, by a national of Barbados outside the territory of Barbados, if that person's conduct would also constitute an offense under the law of the country where the offense was committed. Oh, Lord, you don't have to be a silk, not even an attorney at law, to understand that plain language. I am really disappointed, sir, because that honourable member for Christchurch South engaged the honourable member for St. Michael South Central on the issue. He asked her, does the United States of America have a cybercrime bill? The answer was yes. Does Canada have a cybercrime bill? The answer was yes. Does the United Kingdom have a cybercrime bill? The answer was yes. So in other words, Barbadians living in those countries, and we all know Europe had European Union members, 27 of them, obviously have cybercrime bill because the Budapest Convention applied to all of them. So he knows that any Barbadian living in any of those countries, right, plus another 70 odd, because about 74 countries signed the Budapest Convention, have cybercrime peace legislation, and that this section 3(1)(c) is clear that Barbadians living in any of those countries that have cybercrime legislation, that when we as well pass the Mutual Assistance Amendment Act together with the cybercrime bill, that Barbadians living in those countries will come under the cybercrime bill. But yet, I can hear his voice saying that this isn't true and that this bill brought to lock up Bajans living in Barbados. I totally condemn that kind of opposition politics. As I said last Tuesday, I understand what opposition politics is. I had 5 years, three months of it as part of the last decade when I was an opposition MP. But I always felt you do not try to be malicious. You don't try to play on the ignorance of Barbadians. And I certainly feel I have a responsibility as a member of Parliament to use the doctrine of the Right Honourable Tom Adams. Do not let a lie get ahead of you in politics, because you're going to have hell to catch up with it. I feel it's my responsibility as chairman of that committee to come here today to say that this kind of nonsense has to stop. Stop this kind of political foolishness I don't understand. Why suddenly having joined back the Democratic Labour Party for the second or third time supporting it, you got to now come and prey on the ignorance of Barbadians to try to score foolish political points. No. We got to stop this. And we have a responsibility as honourable members of this House not to go out there and spread inveracities, which we know to be false. Has to stop. And I can tackle it every time once it falls under a purview that comes to me. So the purpose of the act, sir, the honourable member who led this debate spoke about it in compliance with international treaties and conventions of which we have signed on to, such as the United Nations Convention on the Rights of the Child. So we have a bound duty to pass this legislation. As I said, we're late in doing it, but we've finally reached here. The issue of criminal responsibility, the age under which you cannot have criminal responsibility, is cleared up, sir, as 12. And that was an issue because in some spaces it said 14, under some legislations, under some practices. So now it's 12, that is fixed, below which a child is not capable of committing an offense. And similar to the Child Protection Act, sir, this piece of legislation has as its paramount consideration and importance the safety and welfare and well-being of the child. And the child shall, as far as possible, be given the opportunity to respond before any decision is taken which affects it. And you compare this to the situation, sir, which certainly prevailed up to recent times, that we had constituents whose parents, especially the mother, would go before a magistrate and say, I can't deal with this child. This child run a 12-year-old child or well, not 12, 13 or 14-year-old child, 15. I can't deal with this child. This child running about with men. I feel she having sex already, or in fact, I know she having sex, and I want her put in the girls' industrial school. That is what happens, sir. We know that's all of that done with this act now, with this piece of legislation. I got constituents that went in, girls' industrial school, under those circumstances. That's the truth. So the child has to be treated with respect and shall not be treated more severely than any adult would have been in the circumstances. I already mentioned about the 3-year minimum sentence. That gone through the headers now. And in fact, so when I became Home Affairs Minister, May 2018, there were about 50 or more boys and girls between the girls' industrial school and the boys at those reform or detention centers, I would want to call them. And I said, this is nonsense. And at some stage, I released a lot of them there. They told me how I couldn't release them before 27 months. In other words, 2 years, 3 months of the 3-year sentence. And I said, bring the files to me. I believe I might even have released some. It might even have, I might even have released some before the 27 months were up. But if I recall, when I demitted office as Home Affairs Minister, there were about 20 or so between boys and girls at the two institutions. And speaking with the Honourable Member for Christchurch East today, he told me there are only 6 now. Come down tremendously. Because the 12 now. Because the issue is this. And that Honourable Member was correct in his presentation today. He said that he never heard about any white person in those schools. Why even go further? I never hear about any middle economic income child there neither. It's only poor black people, children that went there. And any piece of legislation that has as its fundamental core of penalization poor black people and poor black people children had to be fundamentally wrong. It had to be fundamentally wrong. And that was the effect. That no middle income child walking about at 10 o'clock in the night can come before the court the next morning and get put in any Dodds or girls' industrial school. So this is the context and the significant importance of what we're doing here today within child justice reform and indeed the whole reform of children and their protection. I take what the Honourable Member for St. John said in his presentation just before mine on parent education, and I already praised the Honourable Member for the City of finally getting off the ground the government's parent education program, something which I've been doing through my foundation, and I certainly take note, as I said, of what the Honourable Member for St. John said, that we have to capture young adults, teenagers, even before they become parents, in terms of education of their role as potential future parents. Children with disabilities under the legislation have a right to access to suitable equipment and assistive devices, and I trust that in implementing that. If any child with a disability, God forbid, were to end up in circumstances where they may have to be detained, that they will also be treated towards any special education and increased psychological support, which their circumstances as a child with disabilities may entail and may be required. So I just want to clear up one thing. When I said that it is had to be condemned that an honourable member of this parliament, far less holding constitutional office, ought not to prey on the ignorance of Barbadians. When I say ignorance, sir, I mean lack of knowledge. Because not everybody listens to us in here or follows debates, although there's been a lot of interest in the cybercrime bill. That is the truth. And that is good, because we want to engage the public and we being transparent and accountable. But not everyone is going to be apprised of the bill or of any bill that comes here. And therefore, you can't take advantage of the lack of knowledge of our citizens and feed them with disinformation and abject lies. That is the truth. I regard as taking advantage of innocent people and making them victims of what we are supposed to be doing in here. And that is passing legislation within the best interests of our people. And I totally condemn, as I said, any member who knowing the oath that they take when they have to come in here, then goes, and because Barbadians or people in this country may not be fully apprised and aware and knowledgeable of what's going on, to come and say something that they know is not true. Even the statement about I think ministers, is it? Getting per diems of $1,000 a day. I would hope that ministers speak and clear that up, because I know for a fact that they get no more than US $200 per day. No more than that. I think it's 185. Because when I was a minister, it was 185, I think, US, and I don't believe that has gone up. See, even that kind of situation about how you get $1,000 a day and travel first class, where again, like I said, it'll have to be the ministers to think about. But I don't believe that it's first class at all. I think it is business class or over trips of 4 hours or 3 hours a time. So this kind of, as I say, I am disappointed, really and truly, in the honourable leader of the opposition on these issues. The probation office will have a major role within the context of this bill. That there's a requirement under this legislation for a probation officer to within 24 hours after a child's apprehension to become involved and to assess the child and to intervene on the part of the state in the child to try and keep the child now out of before the law courts. And that point is essential, because as the honourable member for St. George North said, this is Barbados. And all of us know about Barbados. That is how we get in here in the first place. And we know that in Barbados, don't mind you say that the newspapers can't report on a child in conflict with the justice system before the courts. But the village gonna know, and the word gonna spread, Lord, you know, XY child, Maisie child was before the court this morning. And then don't mind that, say that after you serve your 3 years, that your record white clean. But this is Barbados. You're going to be known as a jailbird for the rest of your life. Don't mind you went in there at age 13 or 14. And everybody know, man, look, man, that is a Dodge boy. But I saw that they have people, and it visited on your children too. Because they would say, "Ma, don't mind he fathered it a Dodge boy." Dodge, the government industrial school. So you want to try to keep a child out of the criminal justice system. And the probation office has a serious role in that, and I trust that the Honourable Minister of Home Affairs will ensure that the probation office is given the institutional strengthening, the numbers, the resources, the computerization to make it fit for purpose for this legislation. Again, when I was minister, I know that we were embarking on reform of that office and looking to see how we can give it the resources to, in terms of numbers and computerization as well, included to deal with this bill. That was part of the implementation process that we were looking at to strengthen that department. Because it's all right for us to come in here and pass laws, but we got to make sure that they are effective on enactment. So Section 11, for example, gives a lot of powers and duties to probation officers, which they can only fulfill if they have the numbers. And probation officers, for example, should assess a child within 96 hours prior to the child appearing at an initial inquiry relating to the child. Section 8. Issue of legal representation of the child is very important, sir. In other words, sir, a child must be able to retain your services as a silk if they want that and if they choose to. And therefore, the Section 65 provision, Clause 65 as it is now because it's still a bill, provision that legal representation of a child by the government at all stages of any administrative or criminal proceedings is important. And the magistrate has the authority to only direct detention of a child to the secure residential facility after they've taken into account the probation officer's recommendations. The issue of wandering, sir, that troubled me tremendously when I was Minister of Home Affairs. And yes, as the Honourable Member for Christchurch East said, we had in the bill that I would have taken the Cabinet May 2019, that Cabinet approved in principle, sir, that wandering will no longer be offence, as it is obviously now in this final version of the bill. Wandering again had to be unconstitutional. Had to be unconstitutional, sir. Again, you and I have spoken on this on many occasions. And it took the court, sir, Justice James, when he was in Barbados in March last year, to say that that offence was unconstitutional because it focused almost exclusively on girls. You never used to really hear about boys coming before the court and being sentenced to government industrial school for wandering. Girls of a particular socio-economic category, girls of a particular color. So it had to be unconstitutional. And the court correctly deemed it so, sir. That is the truth. Before Parliament could so deem. The issue of diversion, as we've heard throughout today, is so important and significant to this legislation, sir. And in Clause 34, it speaks to the opportunities that a child will be given now going forward after this act is passed in terms of options to keep it out of the detention center, the education, the counseling, the vocational training, that a magistrate or even the probation officer, the state can say, well, look, you're going to do community service rather than go to detention. And in fact, the child or parent could specify the circumstances there. where you could say, well, I can give community service through the Lions Club, for instance, as part of my punishment, rather than go to jail, rather than go to the detention center. The intervention of probation officers, the child, you could tell, you could make an order that the child is prohibited from going in a particular district or lineman on the block, rather than sentence the child to detention. All of these, and of course, the magistrate has the power to convert the hearing from a conflict of criminal justice system hearing to a child protection hearing under the Child Protection Act. And all of these are options in terms of this transformational piece of legislation, because in every way you're trying to prevent that child getting a criminal record and the stigmatization and adverse consequences which naturally flow from being subject to the criminal justice system. Imprisonment would only be a last resort. That sentence will not be imposed unless the child is 14 years or old at the time of commission of the offense. The issue of this legislation doing away, saying that there shall be no flogging, no corporal punishment or cruel and inhuman treatment of children, degrading treatment of any child in the detention center is so important, because one of the issues which confronted us, our administration, were allegations of children being beaten and corporal punishment and degrading treatment in breach of the international treaties that Barbados has signed. And we heard the Honourable Member for Christchurch East speak on that issue earlier. But certainly, any such treatment is now made illegal under this Act. And you have penalties as well in lieu of any fines or imprisonment for children. So, one of the last issues that I wish to speak about, sir, is the advisory board. And that was problematic too, because under the legislation that presently exists, there's an advisory board. And the role of that advisory board caused conflict previously under many administrations. What was their role? The law said they were to advise the minister, but a lot of advisory boards got into issues with trying to run the government in the industrial schools. And this piece of legislation clears that up with a child justice board, which it is clearly stated under the Act at Section 73 that board can or shall in fact give directions to the director of the facility on the management and supervision of the facility and as regards the welfare of the children, including their education, their training, conduct, safety and recreation. So that issue should no longer arise as to what is the position of the board of whatever named at these detention centers. So this bill, this piece of legislation today is a day that certainly I have waited long to come before this Parliament and debate. It is socially transformative. It comes as a twin to the child protection legislation and as part of course, our social reform and our social welfare reform, sir, because the role of a member of Parliament, the role of a Parliament of Republican Barbados, sir, has to be what is in the best interest of the most vulnerable in this country, sir. And the children who came into conflict with the criminal justice system, sir, children in the first place are among the most vulnerable in this country, among the 4 most vulnerable people
Your
in this
Honourable
country.
can weigh in.
Yes, sir. among the four most vulnerable people in this country. Children of poor people, sir, particularly poor single mothers, sir, among the most vulnerable. And this bill and the whole social welfare reform of this government speaks towards acting within their best interests. And these children being of paramount importance, sir, to the representatives, to their political representatives and this parliament. And it comes as well together with educational reform, which as the Honourable Member for St. John said, has to come, sir, has to come. Reform of the 11 plus and all of that. I know the Honourable Prime Minister spoke 5 years ago about the common entrance being abolished, and when she was Minister of Education, had a vision for educational reform. But I accept that Parliament and Cabinet has to pull the country along and can't move so far forward in front of the people. And therefore, educational reform, while it has to come, sir, may be taking a bit too long for some of us, sir. But certainly reform of curriculum and etc. has to come very, very soon, and is in the process of coming with teacher training in relation to reform of the curriculum. And we look forward as well to immigration reform, to prison reform, to other social reforms within this country, because that is what we are here to do, sir. And I am happy to be able to rise in support of this bill today. I'm obliged to you.